Hi, good morning, everybody. My name is Romy Jurado. I'm an attorney here in South Florida. And today I'm going to talk to you guys about estate planning. I want to make my presentations really interactive. So there is a Q&A button, and there's also a chat button where you can ask any questions that you have regarding estate planning or anything related to it. A little bit about me. I'm an attorney. I've been an attorney for over 11 years. I have a law firm here in South Florida. It's called Jurado and Associates, and we do different areas of law. We do real estate law, probate, immigration, estate planning, of course, trademarks, copyrights, litigation, and anything that has to do with business law, transactions, we handle that as well. And of course, real estate. Today's presentation is on estate planning, but as you will see, there's different topics that get involved, such as probate, real estate. So feel free to ask questions about any of those topics. This webinar is being recorded, and if it comes out good with no glitches, I'll be able to send everybody a follow-up email with the presentation and with the link of the recording probably tomorrow. All right, let me get started by sharing my screen, and thank you so much for joining me here today. I really appreciate it. I hope everybody's having a wonderful new year. All right, here we go, estate planning. I think everybody can see my screen now. If you can't, please let me know in the chat button. So why do you need an estate plan? Well, you want to determine how your assets will be distributed upon your death or your passing. Death, sadly, is a reality of everybody's life, so we want to make sure that we're able to say what happens to our assets. You also want to protect minor children. I personally have 2 little girls, one that is 2 and one that is 1. Through your estate plan, you're able to designate guardians. God forbid you or your spouse are not able to take care of your kids. Who would you want to take care of your kids? Your mom, your sister, your brother? You're able to do that through your estate plan. Also, you want to avoid or lessen the risk of family disputes over assets. We see that sometimes in probate situations where there was no estate plan, there was no will, so it goes down per stirpes, which is the way that assets get distributed if there is no will, and then people start fighting over one thing or the other. Or if there was a estate plan and the will wasn't sufficiently clear, people can litigate over that. So it's very important to have a good estate plan that is clearly said, that says who gets what. You can disinherit people, but you want to make sure that everything is clearly stated. Also, this allows you, when having an estate plan, for you to make a decision of what you want to happen, and you let the court know. Otherwise, the court will distribute your assets per stirpes, and they will make the decision of how assets get distributed. And you can also, through your estate plan, decide who do you want to make decisions in case you're incapacitated. Sometimes it happens that we are not able to make our own decisions because maybe we're in an accident or something. Through a proper estate plan, you're able to designate who is your healthcare surrogate, who will make your medical decisions, what you want to happen with your body. You're able to do all these things through a proper estate plan. So these are the main documents that we're going to talk about, and I'll explain a little bit about each as we go through, but let me give you a little preview. The last will and testament is, it's basically a will. You can have a will that determines who gets what, and you can have it be really thorough and determine your estate plan, or you can have something called a pour-over will, a will that says everything that I have goes to my trust. That takes me to the revocable living trust. A trust is a document that allows you to make decisions on your assets while you're alive so that they're managed that certain way when you pass away. For example, let's say that you have different properties, rental properties. Well, you don't want them to sell them outright upon your passing. So what you put is you put the rental properties in your trust, or the LLC, the limited liability company that owns the rental properties, in your trust. And then in your trust, you can say, I want the properties to be rented until, whenever my child turns 35, and then he or she can decide to sell them. Or you can say, I want the properties to be rented throughout, and this person is the beneficiary, and after that person is no longer the beneficiary, I want it to benefit his or her descendants. You can say that too. You can be as specific as you want. I remember drafting a trust one time where the client wanted to make sure that no assets were sold, that they were all being kept in the trust, because he felt that the spouse may sell the assets and use it for whatever, I think it was in that case, a casino, and lose it all and not be able to have any protection going forward. So through your estate planning documents, through your revocable living trust, you can be extremely specific of what you want the assets to do, to happen to the assets. You can say who they should discuss the management of the assets. For example, you can say that the assets are going to be managed, or the properties are going to be rented by this specific realtor, and that if you have brokerages accounts or investment accounts, that they need to consult this specific business advisor. And if there's an attorney that you trust, that they should consult this specific attorney for this particular reasons. So you can be as thorough as you want in your revocable living trust. And I've seen cases where people create revocable living trust, but they forget to fund them. It is so important that you fund the trust. It's not enough to just create the document. You have to transfer the assets over. We also have advanced directives, right? So it's called a living will and a healthcare surrogate. Basically, these are documents that we prepare so that you tell the hospital, your loved ones, what you want, who should make medical decisions about your life if you're not able to make them, and what you want to happen, right? If you are become a vegetable, do you want them to keep you alive, or do you want them to, like we said colloquially, pull the plug? What is it that you want? You can do all these things through a living will and by designating a healthcare surrogate. We also do a HIPAA release as part of a living will healthcare surrogate, because just because you have children, and this happened a lot during COVID, just because you have children that are over 18 doesn't mean you're going to get their medical information. So a lot of parents think, okay, my kid went to university, to Penn State, let's say, and you can call the hospital if he's in the hospital and they're going to tell you what happened to him. No, they're not. If he's over 18, they don't have to give you any medical information unless you are that kid's healthcare surrogate or you have some type of HIPAA release. So for those that have children that are going away to universities, you want to make sure that you have a HIPAA release or that you're designated as a healthcare surrogate so that you can get that medical information. For those that are in relationships where you are not married, or even if you're married, you still want to have healthcare surrogate and HIPAA release. Hospitals, doctors are very careful not to divulge medical information because they can get sued for that. So you want to make sure that you have those documents. Also, another document that is really extremely helpful, it's called a durable power of attorney. Okay, so a regular power of attorney ceases to be in effect once the person becomes disabled. If the person becomes disabled, then you cannot use that regular power of attorney. However, a durable one, you are able to use throughout, even if they lost consciousness, no problem. So we do a durable power of attorney so that you can manage the assets or whatever financial situation of the person is when the person is not able to do so because they're not mentally, they don't have capacity mentally. You're able to use the durable power of attorney. That durable power of attorney ceases to exist, ceases to be enforceable when the person dies, right? You cannot use a durable power of attorney if the person died. You now have to go into the last will or the revocable living trust. Somebody's asking me, is the trust applied to non-resident owners? Yes, we do actually create trust for foreigners, and there are different estate planning tools, which together with a CPA, we can design in order to alleviate them from certain state taxes, right? Because when somebody dies, everything becomes part of a box, everything that's part of your probate state. And as US people, we have exemptions, 11 million, 12 million. So unless you have more money than that, you're not going to have to pay taxes, state taxes, right? However, and then the tax rate is 40%. However, foreigners don't have that. Foreigners only have an exemption of $60,000. Anything on top of that, they have to pay state taxes at the rate of 40%. So you want to make sure, if you're a foreigner yourself, if you have foreign clients, that they are properly advised so that when they invest in the United States, they create a proper estate plan so that they're not hit, their heirs are not hit with the 40% state tax. And we do see it a lot, sadly, people don't plan correctly. It's not enough to just create an LLC and put the property there, because guess what? The membership interest of the LLC is going to have to go through probate. And if it has real estate, then it's going to be valued at the real estate market value rate. And the foreigner is going to have to pay 40% state tax on that value rate. So you want to make sure that they are properly advised and they have a estate plan, especially if they're foreigners. All right. Forming an LLC can be a estate planning tool. It's actually an interesting one. Why? Because we're able to create LLCs, put different owners, and then through certain language in their corporate documents, operating agreement is what it's called for a corporation as well, say that certain transfers can happen immediately upon the person's death. One transfer that can happen immediately is, for example, if the LLC is owned by husband and wife as tenancy by the entireties, okay? And this is a special legal way of owning stuff. So tenancy by the entireties means that husband and wife own the asset, in this case, the membership interest or the property, and they own 100% of it at the same time. So if one of them passes away, it automatically goes to the other without the need of probate. You can do that in an LLC. You could also, and the law is not too clear on this, but we've been able to use it, include certain language in the LLC so that upon the passing of one of the members, the membership interest passes to the other members. Same thing in the corporation. Now, there's been case law that has allowed this. So far, the law hasn't changed, but you have to understand in the United States, we have a system of jurisprudence, well, specifically in Florida, to where one case can overcome the next case. So as of now, 2023 now, as of now, January 2023, we're able to do this, but I don't know what's going to happen next year. That's why it's always good to go to an attorney that researches it for you. Okay, payable upon death. If you learn anything about today for US people, foreigners, anybody, is that you should name the beneficiaries on your bank accounts. If you have a bank account with somebody else, supposedly that somebody else should be able to have access to it, but you want to check with the bank if you were to pass away. If you have a bank account on your own with nobody else, then guess what? Nobody's going to access it unless they open up a probate. The saddest thing is when there's only $10,000 in the bank account and then the family members cannot access it because they're not in the account. And now we need to open up a probate. They have to spend all this money only to get $10,000. So it's not worth it, or $5,000. What I recommend is payable upon death. What does that mean? It means you own the account while you're alive, but you can say upon my death, I want this person to have access to it automatically. If you want to do this, you go to the bank, you set this up, you get proof that this was set up, right? Because sadly, we've seen situations where the heirs think, no, it was made payable upon death. We talked about it. I know my father did it, and they have no proof of it. So you get proof that it was done, and then you give it to your heir, whoever it is that you're going to make them, pay to. Now, be careful about making accounts payable upon death to minor children. Why? Because now you're going to have to open up a guardianship for that minor child to receive that. That applies to insurance proceeds. Well, if it goes to probate, but if it doesn't, you might be able to get away with it. But if they're under 18, you want to make sure that you don't do the payable on debts to them, because then you're going to have to set up a guardianship setup. Otherwise, you might be able to do it with somebody that's over age or somebody that can manage it for them. You can do a payable upon death to your trust. There's different things that you can do. Okay, we also have something called joint ownership with rights of survivorship. If you and your friend go buy a house and your understanding is that if one of you dies, the other one gets it automatically, then that needs to be in the title. That type of ownership is called joint ownership with rights of survivorship. That means that the heirs of either one, they're not gonna get the property. If your understanding is that, no, they will get the property. If I die, my heirs get it. If you die, your heirs get it. Then don't do joint ownership with rights of survivorship. Do regular common tenants in common, okay? Life insurance is one way to avoid also probate. It's a estate planning tool. Why? Because you can make the life insurance payable to a certain person, and then that's it. It's payable. If you make the life insurance go through your trust, then your trust can determine how that life insurance is going to be managed, who the beneficiaries are, and you can do that as well. If you name a minor child, they are going to have to get a guardian appointed. So these are things that you need to think about. All right, let's see. I see some questions here. Thank you so much for the questions. I love questions. Is it the same for a green card permanent resident as you were saying about foreigners? No, because they're US tax people. So if it's a green card permanent resident, green card holder, it's not the same. It's only if they're a foreigner. Can you put your trust as a payable upon death? I think that you can, but you want to talk to your specific bank because every bank is a little different. And that would be great because now you can decide what happens with that money, right? Who is that trustee? You want to make sure you designate a good trustee, an alternative trustee, because they are the ones that are going to manage your trust. All right, let's keep going. Okay, so what is probate? You're going to see little pictures of cats because I like cats. I actually have a nonprofit for them. If you're interested, it's called Cattorneys.com. All right, so what is probate? Probate is a court-supervised process for identifying and gathering the assets of a deceased person. So basically getting everything into this little box that is called estate. Then when we get all the assets, we have to pay the deceased debts, right? So there's going to be a period of time where the creditors can make claims and say, no, he owed me this, she owed me that. Then once those debts are paid, we will distribute the deceased asset to his or her beneficiaries, either per the instructions in the will or per Florida law. All right, if you do not have a will, then Florida law will determine how your assets are distributed. So again, what is probate? It's a court supervised process. We identify and gather the assets. We have to pay off the debts and the IRS if you have more than a certain amount of money. And we have to distribute the deceased assets to his or her beneficiaries. There is a period where Medicaid, Medicare can make claims, your creditors, credit cards, everybody can make claims to the state, and then they have to be paid off. All right, what is the age? Somebody's asking me, what is the age to be considered a minor under 18? What are non-probate assets? So these are assets, right? If we have a good estate plan, we don't want our loved ones to have to deal with probate when they're dealing with losing us. We want them to get access to the assets. We want them to be able to use it for support, for paying this, paying that. So we want to convert them into non-probate assets, right? So if you have real property, real estate, held jointly by tenants by the entirety or joint tenants with rights of survivorship, this does not go through the probate. Let me explain to you again, tenants by the entirety, that's something that you can have if you're legally married at the time that you acquire the property, okay? Then you both own 100% of the property at the same time. That means if one passes, it goes automatically to the other. All you need to do is record the death certificate. Now, let me explain something because I actually saw this recently. One of my clients thought that she owned the property with her husband's as tenancy by the entireties because she said, it's my husband, we have homestead, we own it. I don't need to go through probate. I looked at the title and it was only on the husband's name. If your husband or wife acquired the property before you were married, what you need to do is transfer the property to both of your names as husband and wife so that you have the tenancy by the entirety protection. It's not enough that you got married. It's not enough. You have to have been married when the property was transferred to you. So if your husband or wife had it from before, that's all good and dandy. Let's do a transfer now to both of you as tenancy by the entirety so that you have this protection. Okay, so that is a non-probate asset if it's joined by tenants by the entirety. Also, if it's joint tenants with rights of survivorship, that was the other example I was giving you. So if I go and buy a property with my friend, and our understanding is I get it if you die, you get it if I die, then you need to own it as joint tenants with rights of survivorship. I've seen deeds where they tell me, no, it was our understanding, I was gonna get it. I look at the deed, they're not joint tenants with rights of survivorship, they're tenants in common. Tenants in common means you own your part, I own my part, and my part goes to my heirs and your part goes to your heirs. So you wanna make sure if you're investing, you're buying property, things with friends, whatever, family, people that are not your spouse, that you have the understanding. What is the understanding? Is it going to be I can give it to my heirs, or is it I give it to you and you give it to me? You have to make sure that you address those things and that it's reflected in the deed. I have done deeds where we say you have 30% of the property, you have 50% of the property. You can do that too. You can get as creative as you want, but it has to be on the deed. All right, let's see more questions. I love questions. Okay. Is the LLC will include a joint tenant? You can create an LLC. I don't know that you can do joint tenants with rights of survivorship. I have done tenancy by the entireties to own the LLC membership interest. Because joint tenants with rights of survivorship is usually just for real estate, but tenancy by the entireties applies to any asset that you can acquire with your spouse. While you're married, you can say that it was tenants by the entirety. So I don't think so. Let's see. Oh, I skipped a lot of slides. Hold on. All right, let's keep going to non-probate assets. Also, assets titled in a revocable trust. Please, if you're creating trust, that's all great and dandy, but you need to title the assets in the name of the trust. Otherwise, it's not part of your trust, right? So real property, bank accounts, brokerage accounts, all those things will not go through probate if they are titled in the name of your revocable trust or irrevocable trust. Survivorship bank accounts, that is what we're talking about, payable upon death. If they're payable upon death to somebody else, then they're not going to go through your probate, right? So the less assets you have in your probate state, the less your creditors, such as your credit card, can attack. Life insurance, IRAs, all of that, as long as you designate a beneficiary. OMG, I have seen where people forget to designate a beneficiary or alternative beneficiaries, because if all your beneficiaries are dead, then it will become a probate asset because now there is no beneficiary. Homestead, right? Real property passing to a surviving spouse or heirs. Also, it's not a probate asset. What does that mean? We still have to open up a probate. Okay, let me say it with a caveat. If it's joint tenants with rights of survivorship, no, you can just record the death certificate. No probate necessary. If it's going to your surviving heirs, then yes, you have to open up a probate. But that is exempt from the creditors. So that's a good thing. Except homestead is exempt from creditors attacking. Retirement accounts, right? If you have any retirement accounts and you name beneficiaries, then it should not be a probate asset. All right, so let's talk about the will. It's the most common document that I see as a estate planning tool. And it's the most basic document, right? And it allows you to provide instructions for who inherits what. If you die and you have assets in your name with a will, it's called testate succession. If you die, you have assets in your name without a will, it's called intestate succession. And then the court, through the law, will determine who gets your assets. Now, here I'm focusing regarding the will, right? I'm going to focus on what is legal under Florida law. We have seen situations, sadly, where they have a will in other countries, but it's not valid under Florida law. And guess what? If it's not valid under Florida law, they're not going to allow it here in the Florida court, and we're not going to be able to use it to distribute your assets. So it might go per stirpies. Okay. So per Florida statute 732.501, any person who is of sound mind, that is so important, the person has to be of sound mind, and either 18 or more years of age or an emancipated minor may make a will. A will must be in writing and executed as per Florida law 732.502. The testator, that is the person doing the will, must sign the will at the end, not on the side, not at the beginning, at the end of the will. The testator's name must be subscribed. It could also be that the testator cannot sign. Somebody can subscribe the name for the testator, but it has to be in the testator's presence and at the testator's direction. And it must be signed in the presence of two witnesses and in the presence of the testator and in the presence of each other. So they all have to be looking at each other, the testator, the two witnesses. If the testator cannot sign, he needs to direct somebody else to sign, and they all need to be looking at each other. Now, the law changed in July, and you're able to do e-notaries, or, remotely. You're able to do estate planning documents remotely. I don't recommend that. I don't know how that's going to turn out. I rather, when we're executing a will for it to be valid, I rather have everybody there in the table, everybody's looking at each other, And if we're disinheriting people, I like to record it, because then they're going to fight and say, no, my father didn't intend to disinherit me. And yes, he did. So we want to make sure that we follow Florida law, the formalities, and we get it done correctly. I personally would not be doing remote online will signings, trust signings. I just don't feel comfortable. Too new for something that you cannot change. All right, let's see, more questions. Thank you so much. Let's see. So Susan's asking me, for a revocable trust, how would you transfer your current properties that have mortgages? That's a very interesting question. So all mortgages, okay, fine. Let's say most mortgages, all right, have something called an acceleration clause. What does that mean? That means that if you transfer without their authorization, they have the power to accelerate that mortgage, and now you owe everything. This happens when you transfer to an LLC, when you transfer to another person, whenever. So to all those people doing quitclaim deeds without your lender knowing, this can happen to you. However, in the case of a trust, I have personal experience where the banks understand that it's still you as a person, right? Because your trust, it's a revocable trust, and it's still you, and you're just simply wanting to fund your trust, and they allow you to do that transfer without forcing you to do a refinance. The best thing, of course, is to do this at the beginning when you're buying the property. But let's say you already bought the property. Then contact your bank and say, listen, I am creating myself a trust, and I want to transfer the mortgage, the property to my trust. Can you allow it? And they might say, okay, but we're still going to keep in the hook in the mortgage. That's fine, of course. but you want to get something in writing so that they don't accelerate the loan. Now, in my years of experience, in my years of practice, have I seen any loan accelerations? No, I have not, because as long as you keep paying the mortgage, the bank doesn't seem to care. However, I have to disclose that it could happen. They have acceleration clauses, so you want to be careful of that. Another thing, if it's your homestead property, you want to make sure that your trust has special language, which of course we put in our trust, so that you're able to claim homestead. Because if you transfer the property, then the property appraiser may say that you transferred it and that you're no longer that you no longer qualify for homestead. I have seen it where other attorneys have done trust. They didn't include that language. So then we have to fix it, fix the trust, tell the property appraiser, no, this is the way it is, blah, blah, blah. So then they allow homestead. Yes, you can get homestead protection on a property owned by a trust. No, you cannot get homestead protection on a property owned by a corporation, on an LLC, you cannot. But if it's owned by your own trust, yes, you can. You just need to include that language so that the property appraiser gives you the homestead protection. Okay. Somebody's asking me if I can get a copy of this class. Excuse me. Yes, I'm recording it. And if it comes out okay, then I'll send everybody a follow-up email with the link for the presentation and also the presentation. Okie dokie. Testate administration. That is when you die with a will. So if you die with a will, not just any will, a valid will under Florida law, right? Then the court only distributes the property according to the person's will and appoints a personal representative as indicated in the will. So there's going to be a person that you can designate who is going to be able to gather the assets, manage the assets, and pretty much help out during this probate process and be the representative in front of the court. You can have 20 heirs. You don't want them all talking to the court. So you have one personal representative that you designate and you say, this is the person that I want to speak on behalf of all the heirs. You can designate one, designate an alternate one, and you can go from there. In your will, you can nominate your guardians for your children. You can do that through your will. You could also disinherit specific individuals. If people have been rowdy to you, your sister, your mom, you can disinherit them, no problem. As long as when I disinherit somebody, I like to be very specific so that they don't fight it, right? So I'm disinheriting this person. This is her age. This is her, date of birth. This is where she lives. This is where she resides. Like you want to be extremely specific so that they don't question the fact that you intended to disinherit them. And also, if we can, I like to record it so that they don't question that you intended to sign that will. Okie dokie. What you cannot do with a will, right? So you can, through your will, you can do everything that I mentioned before, designate who gets what, disinherit people, all of that. But what you cannot do is you cannot devise the homestead property if you're survived by one or more minor children. The law protects minor children. If you have homestead property, you cannot disinherit your minor children, no matter how rowdy they are. So the law protects them if it's your homestead property. Also, if you're survived by a spouse, but no minor children, assuming there's no prenuptial or postnuptial agreement between you and your spouse, then you can devise the homestead outright to your spouse. So you cannot devise the homestead if there's minor children. But if there is no prenuptial or postnuptial, then you can devise the homestead outright to your spouse, right? As your estate planning attorneys, we could always advise you what you can and you cannot do. Absolutely, we can help you with that. What if you die, sadly, without a will? Then what happens? If you die without a will, the laws of intestacy will dictate how your assets pass on death. Your surviving spouse, right, under these laws, your surviving spouse is entitled to all of your individually held assets if you do not have surviving descendants, or all surviving descendants are descendants of both you and your surviving spouse. So under Florida law, if you're married, legally married, and you don't have a prenup, postnup, none of that, then your surviving spouse will get all your assets if there is no minor children, right? Or of other marriages, let me clarify that. Or if all the minor children that you guys have, your surviving descendants, are both yours and your spouse, then your surviving spouse gets it. If there is a homestead property, then what happens is you can record the death certificate, and assuming you bought it as tenancy by the entireties, then your spouse will get it. If you have descendants that are not your surviving spouse children, right, then it's a little different. A surviving spouse is entitled to 1/2 of the decedent's individually held assets if your surviving descendants who are not descendants of the surviving spouse, or you and your spouse have surviving descendants jointly, and your surviving spouse also has descendants who are not your descendants. So let me see how I can explain this so that we're all on the same page. If you're survived by your surviving spouse and your children are in common, then your surviving spouse gets everything. And assuming your surviving spouse has no other children elsewhere and neither do you. If your surviving spouse has her own children outside, or you have your own children outside that you're not sharing and that's all you have, then he or she is only allowed to get 1/2 of that decedent's individually held assets. Okay. And again, we do probate, we do free probate consultations actually. So if you have any of these issues, you can reach out to us and we can tell you who gets what and how we can present it to the probate court. All right, somebody's asking me, let's see, how is intellectual property handled in a state? Also, can you define probate? Sure. So intellectual property will pass just as depending. If it's in your will, then they'll follow your will. If your trust owns it, then they'll follow your trust. If you don't have any of that, then it will go just like intestacy rules will apply to your descendants, depending. If you have a surviving spouse and no children that you on outside the marriage, then it will go to your surviving spouse. If you have a surviving spouse and children outside the marriage, then your surviving spouse gets 1/2 and then the rest gets divided. And probate is a court supervised process where all the assets of the probate state are gathered, all the debts are paid, and then the rest are distributed to your heirs, either according to your will or if no will, according to the Florida intestacy laws. We have something else too, a little kicker. So what if you do not provide for your surviving spouse, right? So you did your will, you did your estate plan, and then you got married. Well, your surviving spouse, if the decedent spouse did not provide for the surviving spouse or did not provide enough to the surviving spouse to meet the elective share requirements, the surviving spouse can take an elective share in the decedent's estate. The elective share is an amount equal to 30% of the decedent's elective estate. Unlike the intestate share, the elective share computation includes the value of assets other than those held in the decedent's individual name, including assets held in the revocable trust. So if you did your estate planning, but you forgot to include your spouse can go and get an attorney and they can claim the elective estate, which will include assets held in the trust, and they can get 30% of that. So it's so important when somebody passes away to be represented, to be advised, because then you don't know about these things. Pretermitted spouse. If the decedent spouse dies, leaving a will made before marrying to, the surviving spouse that does not provide for the surviving spouse may be entitled to pretermitted spouse share. The surviving spouse is entitled to a share of the decedent estate as a pretermitted spouse if the will was signed before the marriage, the spouse is not provided for in the will, the spouse did not waive the surviving spouse's rights, the will does not disclose an intention to exclude the spouse, the pretermitted spouse share is equal to the spouse intestate share. So in an elective share, right, this is when he or she can elect to get 30% of the decedent's elective estate, and it includes assets in the trust, which is great. If you're pretermitted, this is when they don't leave you enough, right? You maybe were in the will, but they didn't leave you enough. But if you are a pretermitted spouse, this is where you were not there at all, you might be able to get everything you would get under the will, under Florida intestacy laws, which means all of it or 1/2 of it if they have children outside the marriage. But you have to go through all these things, that the will was signed before the marriage, the spouse is not provided for in the will, the spouse did not waive the surviving spouse's rights, the will does not disclose an intention to exclude the spouse, and the pretermitted spouse share is equal to the spouse intestate share. So again, if you run into any of those issues, let us know so we can analyze your particular situation. Intestacy succession, again, this is when you die without a will. The intestacy laws also provide an order of preference for a personal representative. This is the person that's in charge of gathering the assets, paying the debts, and then giving it to the beneficiaries, to the heirs, together with the probate court. For an intestate estate, the order of preference is first your surviving spouse. Okay, this is going to be your personal representative. The person selected by a majority in interest of the heirs, so the heirs also can choose the majority of them, the heir in nearest degree or the best qualified heir as selected by the court, or any capable person appointed by the court. So if you do not designate your personal representative, this is the order that the court will follow to designate your personal representative, who, by the way, can also be compensated from the state because it's work. So why should you consider a trust? Well, a will states your instructions, but it does not avoid probate. Assets held in a revocable trust do not require probate administration. If you own property in other states, for example, your family will probably have to open multiple probates and comply with the laws in that particular state. That is absolutely true, especially for foreigners. We have many foreigners who don't live here, obviously. They live in Peru, Colombia, everywhere, but they bought property here in their own name, and now they get a realtor to list, the heirs get a realtor to list the property, and then the realtor realized they can't sell it because a probate needs to be open for the court to allow the property to be sold. If the property would have been owned by a trust instead of that person's individual name, then that wouldn't have gone through probate. The trustee can sell the property. The trustee can sign the deed. So assets held in a revocable trust do not require probate administration. If you have properties in your own name in other states as well, you're going to have to open ancillary probates in all those states. So what is the, advice? Let's set up a trust, or let's set up a limited liability company so that your heirs don't have to go through this exercise of opening probates all over the place because you have assets all over the place. Also, a trust is a private document, okay? It's not a public document. You can also manage and control spending, and if you can direct investments, you can do everything you want in your trust when you're no longer here. You can protect the beneficiaries because they're too young or disabled or incapacitated or irresponsible. You think that they're going to go sell all the assets and then they're not going to have any money to, keep on living. You can set aside funds for support. You can reduce income taxes from state and transfer taxes. You could do all these things with a correctly set up trust. Let's see more questions. If you have a life insurance policy, does that surviving spouse have this rights to the death benefit? If you leave 10% to your spouse, can she demand 30%? It depends who the beneficiaries are. It depends if there was a will or not, and when did they get married. So if you want us to analyze it, send it to us, give us the information, and then we could tell you what would happen under the laws right now. Obviously, the laws are always changing. They can change in the future, but at least we can tell you what she can have a claim to under the laws right now. HIPAA release. A HIPAA release and authorization allows an adult or emancipated minor to authorize healthcare providers to release protected health information to named third parties. First, I said, if one thing you get out of this is to do the payable upon death accounts. The second thing I will say, if another thing you get from this is if you have children that are going to universities, please have a HIPAA release so you can get their medical information. God forbid anything happens to them, they're in the hospital and they're away, they're not going to tell you anything. So get the HIPAA release. In Florida, an individual may authorize the release of healthcare information to an agent by executing either a HIPAA release and authorization form or a Florida designation of healthcare surrogate. Even better, have them designate you their healthcare surrogate. So now you could get the information and you could also make decisions if they can't. Living will and healthcare surrogate. Florida statutes not provide for a written declaration by an individual specifying instructions as to life prolonging procedures. Do you want to be fed through a tube? Do you want them to pull the tube? What do you want to happen to you? You can decide. Florida law now allows you to designate also a person to make healthcare decisions. If you cannot make those decisions, who do you want to make your decisions? And you can designate, maybe you don't want just your spouse to make it. You want your spouse and your sister, or your spouse and your dad, or either your spouse or your dad. You can do it as you want it. This is the time. Don't think of it as thinking of death. Think of it as protecting your legacy when you designate these things. Who you think will have not your best interests at heart, but that too. But who do you think will be more rational at that time? All those things come into mind. All right. Attorney. It's a writing that grants authority to an agent to act in place of the principal, whether or not the term is used in that writing. Now, be careful. Once you do the durable power of attorney, if you give it to somebody, they can use it right away. They don't have to wait for you to be incapacitated. Now, the durable power of attorney works if you're incapacitated, but they can use it right away. So don't give it to them if you don't want them to use it right away. Have your attorney keep it and give it to them when the time is needed, or somebody you trust. This document will assist the principal in handling his or her assets, paying bills, etc. after you're incapacitated. A principal may revoke a power of attorney by expressing the revocation in a subsequently executed power of attorney or other writing signed by the principal. The principal may give notice of that revocation to an agent who has accepted authority under the revoked power of attorney. So if you did a power of attorney, you no longer want them to have that power, you can revoke it, give them notice, make sure your attorney knows, make sure your attorney is the one that's drafting it. And we can help you with all of that all over the state of Florida. Of course, like I mentioned before, powers of attorney are not valid if the person dies, the principal. They no longer will be valid. All right, so there we are. Let me stop sharing my screen now. Well, that's all my contact information is there, right? My email, my phone, Instagram. You can find us in all those Instagram, our website. We also have a WhatsApp that you can contact us to. It's not that number. It's 305-396-8094. That's our WhatsApp. And we're very, very accessible. My team of attorneys, our paralegals, our assistants, we're very accessible. We love estate planning. We love planning for the future. We love to involve real estate, business law, all of that in the estate plan. So you have something robust that will protect your legacy, right? We want to think about our legacies. All right, let's see. Somebody's asking me, where do you get a HIPAA release form? That's something that you can contact your hospital. It's something that we can draft as well. If you want to hire us for that, we can assist you. Somebody else is asking me, would you recommend a HIPAA release form for my mother that is getting older in case she goes to the hospital, or do children have access to that info? Yes, I didn't mention parents, and it's so important. Have your parents designate you their healthcare surrogate, and we can draft those documents for you. Because if you're not their healthcare surrogate, you will not be able to make medical decisions on them, and you will not be able to get their medical information. Now, you could also do just a HIPAA release, so at least you get medical information. It just depends on what they want to give you access to. But absolutely, for elder parents, for children, for sisters, for siblings, if you want other people to get your medical information, have these forms done, okay? Absolutely. Now, we do have different packages in our firm, and we can assist you with your trust, with your will, with creating limited liability companies, with doing the transfer of the properties, with creating a robust estate plan, doing all of the different documents that should be, prepared to have a estate plan. We are Florida licensed attorneys, so we're able to help you with your estate plan all over the state of Florida. And let me see if I have more questions. If not, I'll let everybody go because I know we're all busy. Somebody's asking me, husband and wife own an LLC 50-50. Husband dies. What about the children? Well, if the husband dies, then that 50% has to go through probate, and it goes through the heirs, right? So who are the heirs of the husband? If the children are, of the husband and the husband had no other children and the wife had no other children, then the wife gets all of it. If they had children outside the marriage, then the wife only gets half, and then the rest gets distributed to the heirs. That is basically what happens if you have husband and wife own 50-50. Or hopefully the husband had a good estate plan, created a trust, or did something in the corporate documents, so it doesn't have to go through probate. Otherwise, it will have to go, that 50% will have to go through probate. Somebody's asking me if the fees to set up a trust depend on the size of the assets. No, they don't. We have, estate planning packages. It depends on the complexity that you want. But if you want to reach out to me, my contact information, let me put it here in the chat. I will be able to answer your questions and tell you, what is it that we charge for your particular estate plan and how we can assist you and all of that. So let me put my email there, our office number, and also our WhatsApp. Okay, that's my email, that's my phone number, and that's our WhatsApp. So feel free to reach out to me at any time with any questions. We do handle probate all over the state of Florida. and estate planning as well. So we were delighted to assist you. Thank you so much for joining me here today. I wish everybody a fabulous week, a fabulous new year. I know that this year will be better than the next. Thank you again. Bye.